Good morning, everyone. Welcome you all to yet another knowledge sharing session by Mehta and Mehta. As you are aware, we have started a series on the issue of securities under Companies Act. So, the first session today would be a webinar on the masterclass on issue of securities on right basis. Our Kolkata partner Ravina Dugar, she will take us through this presentation today. Along with this, we have Bala sir, Sudhakar sir, and Bhatia sir as speakers for the webinar today. So, Ravina Dugar, she has more than 5 years of experience in corporate secretarial and compliance field. Her experience includes working in manufacturing sectors like iron and steel and polymer processing, besides consumer sector industries like sleeping mattress manufacturing units. Besides, she has also worked with practicing company secretaries in advisory roles. Her forte includes listing regulations and scheme of arrangements, due diligence, audit, incorporations, and corporate legal consultancy, HR, and placement services. She is also associated with the Institute as a career awareness program volunteer to help students come to a wise career choice. Our panelist for today is Mr. R.S. Bhatia. He is a fellow member of the Institute of Company Secretaries of India and has extensive experience in the corporate sector, having worked for over 8 years from 1988 to 1996. As a peer-reviewed PCS, he has been successfully running his own practice as a consultant for the past 26 years. He specializes in various matters, including RBI, regulations pertaining to NBFCs, FDs, FDIs, issue of shares to foreigners, NRIs, JV, establishing wholly owned subsidiaries, establishment of a place of business in India by foreign organizations, attending compounding and other corporate legal matters and issues related to SEBI, NCLT, and stock exchanges, RD office, Department of Company Affairs, and mergers and acquisitions, takeover, trademark, and other corporate areas. Welcome, Bhatia sir. As you all are aware, issue of securities is one segment wherein all company secretaries have a experience. Like everybody must have done some kind of work in issue of securities. Rights issue, which is a basic provision, seemingly basic provision, but has a lot of nuances. So we would first start with the panelists to share their thoughts on the subject, and then we can take over. Bala sir, over.
Sudhakar sir, I think your view.
I think first let that our guest faculty be there, and after that I will speak. So guest panelist, Bhatia, first you take the lead.
Thank you. Thank you. As rightly said, in corporate line and in the life of the company secretary, this aspect, whether he's in practice or he's in job, right issue is one of the important aspects because it is a normal funding process. Whenever there is a fund requirement and it is not possible to raise from the other outside sources, so from internal sources, that is equity funding, the one of the way is the right issue, that the shares to be raised and the money to be collected from the existing shareholders. Why from the existing shareholders? Because the Act says that the first offer to the existing shareholders. No doubt we can go to others also, but then there is a procedure. It is normally that we prefer to go with the preemptive right, that is the right to the existing shareholders to subscribe to the equity of the company. Then we have this in various other things like a right issue, mainly of the equity, right issue of the convertible instruments. Convertible instrument may be convertible debt instrument or convertible preference shares, where the right issue is there. So, mode we have to decide on, we have to see our various methodologies, what suits our best. Because then, if we are issuing a convertible instrument, say debt instrument which is to be converted, then we have to have some other formalities. Then we have to see that why we are having debt instrument first, because that instrument, the interest being charged is chargeable to the P&L account, whereas equity, there is dividend, and dividend is the costliest mode. Today, equity is the costliest mode of the funding. Then we have to strike a balance in between that. Then there are things that whether the company is a private company or the company is a public limited company or the company is a listed company. Then we have all the different procedures for all these things. Well, we have studied all these things during our studies, but to as a brush up our knowledge, I think today's webinar will give us a thorough light on that how we can raise these funds and how we should approach and what are the nitty-gritties of this. With this, I'll not take much time. I'll request Sudhakar sir to take a lead.
Thank you. Thank you, Mr. Bhatia. Good morning, friends. See, for any company secretary's professional life, one of the significant milestone is issue of securities. Very few company secretaries, according to me, get this opportunity. Suppose if we are having about 60, 70,000 company secretaries out there, especially in my days when I joined the profession, we used to crave for this kind of an opportunity to handle a public issue, to handle a rights issue, or to handle a bonus issue. These are all the dreams of the company secretaries used to be just to handle this kind of corporate actions. Fortunately, in my case, after joining the profession in 1985, within 6 months, I got the opportunity to handle two rights issues of two listed companies in my group, which I joined at that point of time. In fact, when I compare that, the rights issue procedures at that point of time and today's times, it is a huge difference is there. Okay, not even one tenth of the requirements, procedural requirements, what we have today, these were there in those days. But the kind of market operations what it used to be, everything was manual. So the loads of work used to be much more than what it is today because everything is now digitized these days. Everything is on online process. And within 1 week of the issue, you have to make the allotment and complete the listing also. Whereas in those days, we used to have almost 90 days time to complete the whole process. Anyway, much of the difference is there. And another one thing I would like to bring it is this rights issue, as we all know that the renunciation part is mandatory unless until the articles of the company prohibits that. So majority of the companies in those days which were coming with rights issues, rather let me put it this way, there were some gullible companies who used to be there. They used to make a what's called as a fraud on the public in those days. Float a company, get your shares listed, and after that, 1 year or 2 years, bring a rights issue. Then the renunciation forms they used to sell it in the market. Because in those days, public issues, if you make an application, whether you will get it or not, you don't know. And there used to be a long gestation period after submitting the application in the public issue and getting that allotment done. So your money used to get blocked in this particular period. Unlike SBA these days, your money is only blocked in your own account. It will be encashed provided you allotted the shares, otherwise your money is not touched, which was not the case in those days. You have to submit your application form along with your check. The money goes into the that rights issue account of the company, and unless until you get the allotment, your money got blocked. So what people used to do was that this rights issue renunciation forms they used to sell openly for a premium. It may be varied between 3 to 5 rupees per application. It used to be 100 shares, you will get it. That kind of in the market lot used to be 100 shares, most of the companies. So they used to say if you want 100 shares form allotment, you have to pay 3 to 5 rupees per share, something like that. It used to be. So the promoters, what they used to do is out of the promoters' quota, whatever the renunciation is to be there, they used to sell it in the market like that. In fact, in the particular company where I was working, the demand was so much. In fact, I don't know how we did that, but before the rights issue gets closed, we got the date extended and we got the size of the rights issue also extended. How we did, in fact, sometimes I wonder how I did at that particular point of time. Might be the regulations were loose at that point of time, or they were liberal at that point of time. We have done everything legally, but those things cannot happen now. The good part of it, what I want to say is, this rights issue renunciation that has been made into a security as such, a rights entitlement, this is called as. So that means what? Once the rights issue of a company is there, the rights and an entitlement, you will get credited to your account under a separate ISA. And these rights entitlements are traded on the market. If you don't want to subscribe to the shares what you are entitled for, that rights entitlement, you can sell it in the market. The person who wants to buy those shares, but who doesn't have the rights and entitlement with him, he can buy it in the open market and he can make an application. So that procedure is there now. Everything is formalized. This is, according to me, a best thing. In addition to that, during the COVID period, the SEBI also has brought the concept of fast track rights issue, and that is also a very good this thing. In fact, and okay, that participant might be knowing this. During the COVID time, Reliance was the first company which has brought the fast track rights issue. Almost, if I am not wrong, 53,000 crores. That was the largest rights issue in India at that point of time. So I give a pause here, and there are a lot of course, now one thing is there. If any company secretary, whether in practice or in service, if you get the opportunity to handle whether it is a public issue or a rights issue or a bonus issue, one has to be thorough with the ICDR, one has to be thorough with the LODR, and one has to be thorough with the Companies Act provisions. So, considering these aspects, we thought at Mehta that why can't we bring a masterclass on the issue of securities? And if I'm not wrong, that last week we had the issue of, the securities on the initial public offer, and today is the rights issue. And there are so many modes of issues are there, which we will be discussing in the coming webinars. So today, that I'm sure that Ravina might have got made a good presentation, because unfortunately I could not go through that in detail because I was traveling and I returned to India only early hours of today. So I'm sure that she will make a presentation, and during the course of the presentation, wherever I have to give my remark, that value addition, I will do that. So I give a pause here and request Bala to take it forward. Thank you.
Thanks a lot, Sudhakar. You made my job very easy because elaborately you and Bhatia has actually given enough introduction on the right issue, its nitty-gritties, even comparison with the olden days and today's regulation, which is really very good thing. Only thing here, as you rightly said, yes, many company secretaries may not be able to get this out of the experiences in their lifetime. Some may be lucky to get the experience, some may not be able to get the experience. That is all the things are there. But one thing is very, very clear. When we talk about the right issue, there are a lot of nitty-gritties which are involved. Yesterday, when we were talking with the Bhatia Saab, we exchanged a lot of things on this, especially on the renunciation rights and rights entitlement, etc., and all those things. And I think, as you rightly say, Ravina has made a presentation. Of course, Mr. Bhatia, credit goes to him for giving the various inputs, etc., and other things and all. I must acknowledge my thankful to Mr. Bhatia, sir. And I think today we will have a look at it. Only thing is the presentation is divided into two parts. One is the companies procedure which are applicable under the Companies Act. That means those companies who are moving for the right issue who are not listed in the market. Second thing is that the listed companies, because she is going to initially take what are the provision relating to the Companies Act, and then she will talk about the LODR regulation with the ICDR regulation. That's the thing. And I request all the participants, as usual, put their queries and questions on the chat box. We will be taking it periodically as and when the presentation goes on, and we will try to answer everything. At the end of the session, probably we will permit you to raise your hands. We can discuss further on that. I think I give a pause here. I ask Ravina to take over the presentation. Over to Ravina, please.
Thank you so much, sir, for such a great introduction. Yes, the uh, presentation has been made with the help and under the guidance of Sudhakar sir, firstly, Bala sir, and Bhatia sir. Thank you so much, sir, for your inputs. I'll straight away move towards our today's topic, which is issue of securities on right basis. We know that it is a way of type of right issues are a type of securities, but what is actually issue and what is securities? So to start with, that in case a company is looking for an effective way to raise capital without diluting control or seeking external investors, right issue is an answer. This process grants existing shareholders the exclusive right to purchase newly issued shares in proportion to their current holdings. Strategic move often adopted by companies to foster loyalty amongst the shareholder while maintaining its ownership structure, thereby fueling the company's growth. With this, we shall examine the right issue. So, what is issue actually? The process.
Just 1 minute, Ravina. Let me also add 1 minute, Ravina. Let me
Yes.
also add to what you said in the first slide. See, this is one of the ways how the management can reward or the board of directors can reward the shareholders. As we know that how a company can reward its shareholders, there are a few ways. Number one, capital appreciation in the market. That means the company has to work very hard, make good profits, make good products, and enhance the image of the company. And in turn, it will lead to the capital appreciation. Second thing is the dividend. Year after year, they have to reward the shareholders with the dividends. But it may not happen in the beginning of the any company's life. They may not be able to give the dividend in first 2 3 years. There may be a little bit of capital appreciation, but the dividend may not be there in the initial years. So third way of rewarding the shareholders is the bonus issue. Of course, that takes time, but at least one decade. Only after that, the companies can issue bonus shares, unless until the company is in some kind of what's called IT industry or something like that. The fourth way of rewarding the shareholders is to bring the rights issue. Now, in the rights issue, what is the advantage? Number one, as Ravina has rightly mentioned, without dilution of the promoter holding, not only of the promoter holding, even without dilution of even the other shareholding also, any of shareholder, by way of rights issue means everyone will get uniformly the rights, whatever the ratio is there, in that ratio they will get it. If I am whatever one share, if I am having it, I may be 1:1 or 2:1, whatever the share it may be. And to a large extent, the companies always fix the price of the rights at a lower to the market. Suppose if the market, your share is going around 100 rupees, that you have to reward the shareholders by issuing it at 90 rupees, 85 rupees, something like that, so that they will have some kind of a benefit. Because what is going to happen is after the rights issue is right shares are listed in the market, the capital base of the company is increasing, it is going to impact the share price in the market. So that shareholder, the existing shareholders should be able to absorb that. That is the main reason why always the price of the rights issue should be lower than the market. Yeah, Ravina, please go ahead.
As sir rightly said, so what is actually issue? The process of offering securities to raise funds from investors is called an issue. Companies may issue securities to fund their operations, expansions, or other financial needs. Securities can be offered in multiple ways. Companies may offer public security to the public under IPO for the first time or a seasoned issues, in which an established organization offer additional securities to the public like right issue, ESOS, bonus, etc. These are the ways where we can raise funds. One is public issue, which we have discussed in our webinar, which happened in last week. Right issue, which we are discussing today, and bonus issue, private placement, which we will be discussing further in our upcoming webinars. So, a right issue is an invitation to the existing equity shareholders to purchase additional new shares in the company. In a right offering, each shareholder receives the first right to subscribe the shares at the discount as compared to prevailing share price. Right shares are issued to existing shareholders in proportion to their existing shareholdings. Existing shareholdings can trade the rights as well. Why the company does right issue? There are various reasons, but majorly to raise large amount of capital, having longer gestation period, suitable in those projects where debt or loan is not available. Company can improve debt to equity ratio or to pay off the debt to ease the financial strength. Here we see shares under right issue shall be offered to existing equity share of the company by sending a letter of offer subject to the following condition. Number one, the offer shall be made by a notice specifying the number of shares offered, limiting a time not being less than 15 days or such lesser number of days as may be prescribed, and not more than 30 days from the date of the offer within which the offer is, if not accepted, shall be deemed to have been declined. The offer shall be deemed to include right of renunciation unless the article of company otherwise provide, and the notice referred above shall contain a statement of this right. The offer can either be accepted or rejected by the equity shareholders after the expiry of the time specified in the notice aforesaid, or on the receipt of earlier intimation from the person to whom such notice is given that he declines to accept the shares offered. The board of director may dispose them in such manner which is not disadvantage to the shareholders of the company. The right issue is governed under Section 62 of Companies Act 2013. It says whenever any company comes out with further issue of shares, it must be offered to existing equity shareholders and in proportion to paid up share capital as nearly as circumstance admit, subject to the following three conditions. Offer period will be of minimum 15 days and maximum 30 days. Exemption has been given to private companies and IFSC public company that offer period can be less than 15 days if agreed by at least 90% members. Unless the articles otherwise provide, renunciation is allowed partly or fully. Remaining unsubscribed shares will be disposed by board to the best of interest of the company. To employees under scheme of ESOP by passing special resolution in general meeting, to any other person by passing special resolution in general meeting, and valuation of shares to be done by registered valuer. 62(1)(a) subsection 2 says that unless the article of the company otherwise provide, the offer aforesaid shall be deemed to include a right exercisable by the person concerned to renounce the shares offered to him and any of them in favor of any other person, and the notice referred to in section 62(1)(a)(1) shall contain a statement of this right. Renounce of shares can be made to any person whether they are equity shareholder or not. Renounce of shares can be made fully or partly. Here we see what is the procedure of issuance of right shares under Companies Act 2013. Check authorized share capital of the company. In case of insufficient authorized share capital, the company is required to increase its authorized share capital up to the appropriate number for the proposed right issue, to check whether the provision of AOA or MOA implies that the company can issue the shares on right basis. Conduct a board meeting. The company is required to conduct board meeting to obtain approval from directors of the company for the purpose of right issue of shares. While calling board meeting, provision of Companies Act secretarial standards shall be followed. Dispatch the letter of offer. The letter of offer shall be dispatched to the existing equity share of the company at least 3 days before opening the issue through registered post or any other means. Offer will be opened for a period of minimum 15 days and maximum 30 days. However, as we know that in case of public company, it can be lesser if 90% of the members give consent. Acceptance of offer. The shareholders are required to accept the offer within the offer period as mentioned in the letter of offer. In case offer is not accepted before the expiry period, it is considered declined. The offer shall open at least 3 days after the issue of letter of offer. Filing MGT 14 within 30 days, receipt of applicant. After we file the MGT 14, the shareholders who have accepted the offer are required to send application money to the company. After we receive the application money, the company has to conduct a board meeting for allotment of shares. Otherwise, the allotment shall be done within a period of 60 days from the date of receipt of application money. Otherwise, the money so received shall be treated as deposit. Filing of PAS 3. After we receive the money within 30 days, we have to file PAS 3 with the Registrar of Companies. Then issue of share certificate. The company is required to issue share certificate in form SH1 to the shareholder within a period of 2 months from the date of allotment of shares. The particular of every share certificate issued shall be entered in the register of members of the company maintained, indicating the date of issue. So here is the gist of time period and documents. So documents which are required for completion of the issuance of right shares, like letter of offer, letter of acceptance, and letter of renunciation. Time period within which it has to be done, minimum 15 days, which was inserted by the Companies Act 2020, notification dated 28 September 2020, and maximum 30 days. Here is the gist of procedure of the right issue authorized by AA, board meeting, then filing SH7 and PAS 3 within 30 days. Now we are going to discuss compliance in case of issue of shares to non-resident. In case shares are...
One minute, Ravina, 1 minute. Just before you go further, uh, definitely, as I have mentioned initially, and now whatever we have seen so far, whether the company is a listed company or unlisted company, in case of issue of securities, the procedural part is very, very important. And very minutely, the company secretaries have to comply with the procedural part. So now, if it is a unlisted company, obviously the procedure is slightly less. If it is a listed company, it is more. So you need to have a kind of a checklist or whatever we may call it as you have to prepare. But several times it happens that a question may come. The management or the board of directors or the CEO may ask the company secretary, look, we need to augment the funds. Which issue you recommend to the board? Is it going to be should we go with a public issue? Say, for example, my company is an unlisted public company or even a listed public company also. Should I go with the FPO, follow-on public offer? Should we go with the rights issue? Or should we go with a preferential allotment? What is the mode of issue of securities? As a company secretary, in fact, when in one of the forums when I was asking this question, the company secretaries, some people they said that, sir, it is the responsibility of the CFO to devise or to decide the mode of the issue because he is the person who is responsible to augment the funds for the company. According to me, I differ to with that thing. It is also the responsibility of the company secretary. Sometimes even he has to take the lead to suggest to the CFO, which is the right way of issuing the securities. So question is, should we go with the rights issue or should we go with the FPO or should we go with the, as I was mentioning to you, that in case of any issue of securities, other than the way of rights issue, except the ESOPs, you have to take the approval of the shareholders. Even for the ESOP, of course, the scheme is to be approved by the shareholders again. That means any issue of securities to the other than the existing shareholders, you need to have the approval of the shareholders so that their existing equity is not getting diluted. Number one. Number two, as I mentioned that if you want to reward your shareholders, always it is advisable to have a rights issue. But sometimes it may so happen your existing equity may not be that big enough with the rights issue, you may not be able to garner the funds requirement. If it is a huge requirement of the company want to take up a big project, and the requirement for the funds is much more. And you got a gut feel that the existing shareholders may not be able to cough up that kind of, they may not be able to subscribe that kind of rights issue. So you have to see the size of the funds requirement. Based on that, you may have to go for a public offer. Or if the funds requirement is not that big enough and you are confident enough that the existing shareholders can fund the company's requirements, you can obviously come with the rights issue. So sometimes it is a responsibility of the company securities, and you cannot leave it to the completely to the CFO or to the CEO only. So we do need to understand about the modalities of the issue, the codes of the issue of securities, and how to advise the management so that yeah.
Sudhakar,
Go ahead, Ravi.
I like to say here one more thing also, as you rightly say. In fact, our institute has been doing very excellent job in bringing the guidance note. In the past also, I actually said, you also shared actually. In fact, even on the right issue, ICI guidance note is actually available. The ICI guidance note, if you want to go through it, it covers the entire legal procedure. It not only covers that, it also talks about what are the things which are required to be included in the offer letter itself. One has to take care and other thing and all. What are the requirements sending the offer letter? Everything is very detailedly discussed in our guidance note actually, which is very, very useful guidance note. I think people who are in this forum, they may like to go through this guidance note whenever they have the opportunity to have the better understanding. That's what I would say. Another thing is Bhatia Saab, he has been actually in the line for the over so many years, handled many IPO issue, many right issue, many other things involved on this. Your view, please, Bhatia sir.
Rightly, sir, as Mr. Sudhakar said, that the company secretary's role in deciding and guiding the management is too important. And one thing I have seen in my practical life that our professionals are not that equipped with that decision-making process. They do not know how the expended equity will affect the company's working, how the debt equity ratio will be serviced, what will be the burden on the company on this equity, what will be the liquidity position in the market when the quantity of shares will increase, whether with the right there should be a split also to make it more lucrative, that the value of the share available in the market should be there or not. So many things we have to make a note before taking the decision that what should be the right approach. As Mr. Sudhakarji has rightly said, we should go with the what kind of instrument. That is one thing more important, that if we, as I in the beginning said, that decision making, that today we make out a right issue, but we feel that today it should be a convertible instrument, so we can have a convertible instrument, say debentures convertible into equity, so that initially for some period it is a debt which the company can service and the company's P&L account can take the burden of that. The income tax benefit is there on that. But when we have the equity at the end of the day, my what will be my EPS, how it will affect the overall company's position. So a detailed study, a detailed note is required before we take a decision. Well, Ravina, please.
Just add further what Mr. Bhatia has said is that no doubt the company secretaries in the initial formative years they might not be knowing. But what I'm trying to say is that time has come now for the company secretaries also to, in fact, that is one of the reasons that why ICSI is organizing, if I am not doing a certificate course on issue of securities also. So my advice to all the participants is to please, whenever your company is coming with a any kind of issue of securities, or you have in a near future it is going to have issue of securities, please do join this ICSI certificate course of issue of securities. Enhance your knowledge, because see what happens is most of the times I have seen that company secretaries, the moment they graduate, at the moment they get the membership of the institute, they think that as and when something comes, I will refer to the act. by merely referring to the act is not sufficient. Let us not confine ourselves to the compliances only. We have to look beyond now. See the way the regulator is recognizing our profession, especially with the recent recognitions under the amended listing regulations. It is an onerous responsibility is there on the company secretaries. So we have to enhance the knowledge not only of the legal provisions, but also of the other aspects. As I was mentioning to you, when a company has to come with the issue of securities, you have to understand the modes of issue of securities. Of course, definitely we know that whether it is a public issue, rights issue, bonus issue, preferential, blah 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 and all. But which issue for what purpose? And similarly, what is the how you will fix the price? Can we leave it to the CFO completely? Why? Why not even the company secretary to have a say on that? If you have to have a say on that, definitely you need to know the dynamics of fixing a share price also. Say, for example, the CFO, out of his anxiety, he is fixing the price of the share on a very higher side. What will happen the moment it gets the shares listed in the market? If it is not able to sustain that kind of a price, what will happen? Obviously, it's going to impact the market share. So, that point of it is the company secretary's responsibility also to have a say in the determination of the price, whether it is a public issue, whether it is a rights issue, it is immaterial, or a preferential allotment, as a matter of fact. It is immaterial. So, for that, we have to enhance and equip the sufficient knowledge about the market operations, about the dynamics of fixation of the price, about the dynamics of determination of the price, the impact of that. All these things we need to have that thing. I'm sure that the participants are also equally interested in all these things. And if I am not wrong in the certificate course of ICSI, I'm not what's called as promoting that, but I go as a faculty on one or two issues and okay, that I addressed the issue of this certificate course, and I'm sure that it must be certainly useful. Yes, Kavina.
With due respect to Sudhagar, one thing is there, Bhatia Saab said actually some time back, some other his practical experience, our company secretary is not that much equipped in the practically. That's what he actually said. What is actually required really is having, we are all not having that sort of the courage of conviction. I remember your word, if the company secretary's voice is actually heard, that is one thing you always used to say. So really speaking, we need to rise to the occasion. That rising to the occasion, speaking it, we need to develop the courage of conviction. We need to actually bring to the notice what can be done only knowingly very well and doing our homework. To that extent, we need to actually rise our occasion ourselves. Otherwise, I don't think it's all going to be like that only. Yeah.
See, in
Well,
fact, this
sir,
is a debatable issue.
I will
This
add
is a
one thing
debatable
here.
issue. Just 1 minute, Bhatia. This is a debatable issue, no doubt about it. We always say that company secretaries is like this, like that, and all. But according to me, it is the responsibility of the senior company secretaries to sensitize the budding company secretaries or the company secretaries who are in the middle age. Right, this is what the thing is. The profession is in a transforming phase, according to me, and this transformation is giving a lot of opportunities to the professionals. So instead of saying that, look, what we do with our children, we always we go to our children, we persuade them, we convince them by look, do this, do that, and it is going to be beneficial to you. Whether they listen to that or not, it is immaterial. So all the three of us who are here, we are in the last leg of our professional careers. So a time has come for people like us. We have to sensitize the participants. Look, this is for the betterment of yourself first, and in turn, it is for the betterment of the profession. So a time has come. You have to have appetite and a good hunger for knowledge if you want to really survive in this profession, and if you want to uplift and keep the image of the profession also. So for this, in fact, one of the reasons why we take up these master classes in Mehta is that we decided that let us do that sensitization part. Whatever the little bit we can do from our firm, let us do that. In this process only, these kind of webinars we are organizing it. Yeah,
Yes, but,
Kavina.
but yes, sir.
But Mr. Bhatia, you want to say something? Sorry. Yeah,
Well,
please go ahead.
sir, my humble submission is why I said it, as Mr. Sudhakar ji said that at the point when something will come, the But in company secretaries, they say that we will refer to the act or the regulations. But as I have said that before deciding for the right issue, which instrument we should come, Act will not tell you whether it is a preferential, whether it should be a convertible instrument or a pure equity, and pure equity at what price. That all Act will not tell you. It will be only your studies based on your parameters, financial parameters of the company and your need requirements. For what purpose, as Mr. Sudhakar said, the object of the right issue, whether it is for funding of the changing the our debt with the company, we will replace the debt with equity, but what will be the long term benefit of it, whether it is the gearing on equity, whether it is for capital expenditure, or whether it is for any other general corporate purposes. We have to see whether the why the SEBI has also put up a cap. Earlier there was no cap. Now SEBI has put up a cap. If the right issue is for general corporate purposes, there should be only 25% of the component of the total. It cannot beyond that. And if you are coming out with something else, then working or any other capital expenditure, then 75% of that must be tied up. You can only raise 25% of the funds. So all these things they have to decide on, see what kind of thing is there, what kind of leverage we can take it, how we will service the equity in the as Mr. Sudhakar ji said, what will be the impact on the capital market, where my shares will fall after the right issue, what will be the impact. I am not expanded my equity to that extent that I cannot manage it. EPS matters a lot. So many factors we have to decide on before that. So as Mr. Balaji earlier said, this is the occasion when the company secretary should come out from the ambit of not only the, I'll say, the hesitancy, but from the impact of the Google. Today they just go to the Google and see what this is, this is, they say they don't study the impact. I'm very much worried about that. It is only Google. Now the AI, we can say, our brain, our thinking, where it has gone. Nobody implies it. Please.
Yes, Ravi, now go ahead.
So after a good discussion on ICSI, we come back to our topic where we'll be discussing issue of shares to non-resident. The company is required to file Form FCGPR with the RBI within a period of 30 days from the allotment of shares. The following documents are required to be submitted along with Form FCGPR: declaration to be filed by authorized representative of Indian company, CS certificate, valuation certificate, PAS 3, along with the board resolution, memorandum of association, merger or demerger amalgamation if applicable, then specified attachments. For right issue, acknowledgement letter of FCGPR or FCTRS as applicable, FIRC or debt statement and KYC at the specified attachments, government approvals, if any. So we have come to an end where we have discussed right issue as per Companies Act. Now we are coming to our part B, which is right issue for listed companies, which is governed by SEBI ICDR regulations and SEBI LODR regulation.
I think Bala, why can't you take some questions before we go to ICDR?
Yeah, we can do that.
Yeah.
A private limited company wanted to issue the right issue. The renunciation can be done to the third parties or only to in favor of the existing members.
To the third parties as well, if pronunciations.
Okay. Under the section 62.
No, one minute. Bhatia sir, would you like to throw some this thing on this? Please do that.
Well, again, Mr. Bala sir, I would like to say that my learner friend has not read the law itself properly, because the law is very clear: renunciation in favor of anybody. Renunciation means you can give shares either to the existing shareholders. In the slide, Ravina ji has also covered it. and to an outsider, whether he is an existing shareholder or not, and that too without passing a special resolution. There is no requirement for that also. So
Not only
renunciation can be
that,
in
not
favor.
only, yeah. See,
Yeah,
not
please,
only
please.
that, in addition to what you said, in case of a private company,
Hmm.
can you open the renunciation? Don't you want to restrict that? Otherwise, what will happen is everybody and anybody can join you. Any shareholder can renounce the shares to even anybody who is not an existing shareholder. It is not required, as you rightly said, Mr. Bhatia. Now the question comes that in case of a private company, mostly it is a closely, I mean, the family members, at the most one or two outside friends may be there.
Hmm.
So in case of private company, and second thing is, suppose say in the term of issue of this renunciation of shares, if the number of members go beyond 200, what will happen? You cannot restrict that. So you have to have a restriction in the articles of private limited companies that renunciation should not be allowed. At the same point of time, even in the letter of offer also, you have to very clearly mention whether the renunciation is permitted, if permitted, with what conditions. If it is not permitted, nothing to do like that. Most of the times, private companies, they don't allow the renunciation. Yeah, Mr. Bhatia.
Well, I will add one more thing here, sir. As you have rightly said, there should be a provision in the articles to what extent renunciation is available to the existing or to the outsider. Now, another question, very important question, is that this renunciation can even subsequently lead to the change in management. If anybody acquires 10% and more, he can do anything. So management has to take that. It can be taken as a preemptive right or not. That all things have to be considered.
Under Section 62(1)(a)(3) of the Companies Act, can shares waived by the existing shareholders in the right issue allotted to the outsiders, given that the board of the authority to dispose of that shares not subscribe in a manner that is not disadvantageous to the shareholders of the company.
Question is not clear.
Can shares waived its existing shareholders in a right issue allotted to outsiders, given that the board is actually having the authority to dispose of that share to subscribe the manners in not disadvantage the existing shareholder. I am also not clear what he is exactly saying. Can the share
Hey,
See,
let me put it this way. In case of a rights issue, there is no question of waiver. Either you subscribe it or you renounce it, provided it is permitted, or you don't subscribe it. If you don't subscribe it, what will happen is the issue is undersubscribed. Whatever the unsubscribed portion is there, normally when you take the rights issue resolution itself, you will also not disadvantage. So, point of time, it is a decision of board to not the shares. Rights issue entitlement is, say, for example, one share right 100, I might be subject to 50. So the subsequent portion is that the applicants who are applied for both the companies ratio that company board allows to them.
how to determine the right issue price in case of the unlisted companies?
sir, as I have already said in the
Yeah,
beginning, there is no basis given. Right issue price, of course. We have to see how much benefit, as Mr. Sudhakar has said, to be given to the existing shareholders. So there are two things involved in it. A, what is my existing strength based on which I can charge my premium? Second is law does not, Section 247 does not contemplate that valuation is required in case of right issue. But now the question comes, when there is a right issue, valuation is required or not? I'll say yes. Why? Because in the Income Tax Act it is required, not in the Companies Act. Because income tax does not distinguish between an ordinary share or a right issue. There is a issue of share. And whenever there is any issue of share, and if the company has charged a premium which is beyond their value, then that will be charged to taxation. And if it is the beneficiary, they will charge tax to that. So valuation is required for the purpose of income tax. It is advisable that the price of the right should be comparable to the price as given in section 56 that with 11 UAE rule, so that tomorrow companies should not face any difficulty with the income tax authorities.
Okay. If the right issue is not subscribed, whether the board can actually issue the share with the best interest of the company?
Yes, sir. Section allows it.
Can the share application money be used before the PAS 3 is filed?
Why not, sir? No restriction.
In the right issue, is it the right issue is actually compulsory? And the pricing
Pardon?
should, is the
1
right
minute.
issue,
Bala, 1 minute. What Mr. Bhatia has rightly said is in case of rights issue, can the company utilize the money before the rights issue is closed? It is a very fine point here. It is in case of an IPO or in case of private placement or preferential allotment, you have to open a separate bank account and you have to park the money there and you can utilize the proceeds only after the allotment is made. That kind of restriction is not there in case of rights issue. That is the reason what Mr. Bhatia said is correct, that you can utilize the money. Another thing is that we all know once you make an application for any issue of securities, before the allotment, you can withdraw that. If I am not wrong, in case of rights issue, that privilege is not there. Once you make the application, you cannot withdraw that application. You have that is the only reason why you can utilize the proceeds of the rights issue.
if the right issue is actually compulsory and the pricing should it be necessarily less than the face value, it can actually slightly lower than the price under which the issue will be actually given to the public, or less than the face value, can the two discriminate for the company raising the funds when they make the issue comparatively higher? I think the price cannot be lesser than the face value of the share.
Right.
Correct.
Yeah.
Share cannot be issued at a discount.
Yeah, when you talk about the face value, you cannot issue under the discount because it has to be necessarily more than the face value.
What I
Share
said
cannot.
was less than the market value, not share
Yeah,
value, face
the
value.
offer value rather.
Yeah, see,
Sir,
suppose
but
in
in the
case of
case of
unlisted companies, it may be less than the book value of the share. In case of listed companies, it can be less than the market value of the share.
Correct.
any price, there is no restriction. Section 247 regarding valuation not applicable.
Yeah, practically in the listed company, the right issue comes a little lesser than the market, because if they are offering the market price or something like that, then why should they subscribe for the right issue? They will as well
Why
buy
they
from
will
the market.
why will they subscribe?
Yeah, they can as well buy from the market rather than that. So
Right,
it is
right.
necessarily, in practically, it is seen all the right issues are lesser price than what is in the market value actually quoted. Yeah.
And one other factor is, sir, that after right issue, that the liquidity base will expand. Quantity of the shares availability in the market will also increase. That also brings temporarily down the value of the shares. So all that factors has to be considered.
No physical share certificate to be issued. Shares shall be issued only on the allotted demat. Yeah, that is right. That is required. Except for the small companies, the exemption is not available for the issue of the share. It has to be in the
Only
demat
demat.
list form only. Yeah, only demat.
Only
Since
demat.
the share has to be issued in the demat, share certificate and ROM requirement will not applicable, right?
You're right.
Can a company close the rights window within 15 days based on the response?
Well, sir, it cannot close, but it can allot the shares in
Do,
trenches also.
do you need to open the separate bank account to collect the right issue when the set? I think Sudhakar has already discussed it.
Already covered. Already.
In the earlier, he has already covered it. Can a company shareholder to whom right issue has been actually offered renounce the share in favor of the other company which is not a shareholder? Yeah, he said it can be in anybody. That is what you have given
Yeah,
actually answer earlier.
already replied, sir.
Yeah. In the right issue, there is a disadvantage of some of the regular shareholders and unwelcome shareholder can become shareholders on the renouncement and shares existing ones. What are the action does the company exercise against this possibility?
So Sudhakar has already said that the right can be in the articles. We
Restrict.
can write down what kind of rights can be renounced or what kind of powers board can exercise on that. So
Yes,
if you have any apprehensions, amend the articles beforehand and bring out all the provisions in the articles, and then write down in the letter of offer itself that these are the provisions there in the articles, and the board will act accordingly in case of renunciation of offers.
SH7 is required to be increase the authorized share capital and not for the paid up share capital. No,
Correct.
SH7, what she mentioned is actually if the authorized capital is not sufficient enough to accommodate, you know, to
Increase the authorized.
amend the article and accordingly you know to pay the SH7. That is the thing.
Ravina ji has already covered.
Yeah.
Yeah.
If it is a separate listed entity itself, then should the company go for actually rights issue? Since the new company itself right to issue is not compulsory.
Not clear, sir.
I am not getting the question clear.
Hmm.
If it is a separate listed entity itself, then should the compulsorily go for the right issue? Since the new company itself, the right issue is not compulsory. No, I'm not very clear actually what is asking. I think Rashti is actually given a checklist actually for these various issues. I think thankful to you here. Please clarify whether it is possible to offer the equity share on the right issue basis as per the value instead of it may be determined by the registered valuer.
Already replied, sir.
Either any restriction on the ratio of the right issue. I mean, what can the maximum ratio of the right issue?
No, in the best possible ratio, Act section itself is clear on it.
Right issue and letter of offer would be approved by the board of directors meeting. Is it the allotment share can be made through the circular resolution or the right issue be approved at the board meeting only?
Issue is to be approved at the board meeting as per section 179. It is mandatory. MGT 14 is to be filed. Then allotment can be done through RBC or via allotment committee, whatever mode they want.
Sudhakarji, somebody has given you the compliments to you. It is not only you are having the wings, but it is not just a leg, you have a wings.
Excellent. 3 years.
What form is required to be submitted to the existing NRI shareholders of the company?
Madam?
What form is required to be submitted by the existing NRI shareholders of the company?
Form is not different. It is the mode of payment which has to be specifically given that how the NRI shareholder are to make payment. It is through NRE account, SCNR account or NRO account and what mode is there. Probably that is the only portion where they distinguish. Otherwise, form is common.
Normal.
Under the Companies Act 2013, can the right issue be made a preference share, debenture, any type of the convertible instruments, whether fully convertible or optionally convertible?
Yes, I have already replied, sir. Yes, it can be done. But in case of not fully convertible debt instrument, we have to see the provisions of the deposit rules in this regard also.
Should we include the issue related expenses in the general corporate purpose expenditure or not?
Yes, it can be.
Well, 1 minute. In the previous question, under the Companies Act, can rights issue be made for preference shares, debentures in any type of convertible, blah, blah, blah. The answer to that is, though there is no legal prohibition as such, how can you make a rights issue to a preference shareholder? It has to be a different series altogether because, say, for example, that existing preference shares are to be redeemed on a particular day. So, issue of preference shares again to the preference shares has no meaning. you have to issue a separate series of preference shares. And the same is the case with the debentures. If it is a purely debenture, the terms of the debenture issue may be same, may be different. So the interest rate may differ. So how you will do that thing? No doubt about it. If it is a convertible debentures, if you are coming again with your rights and all, so it is though not prohibited. When you are devising that kind of an instrument, you have to be very careful and you have to make it attractive. Otherwise, what will happen is people may not even subscribe to that.
The PPT for right issue to NR, note number 3 says actually the right issue valuation certificate is not required, but the last line says the valuation certificate should not be more than 90 days old on the date of the allotment of the shares.
See, for rights issue, no valuation certificate is mandatory. Only mandatory it is preferential allotment, and only in that case this validity of that the valuation certificate is there. For rights issue, it is not mandatory as such.
Is the valuation certificate required for the allotment to NRIs?
For rights issue, not required according to me.
Okay. CS and employment in Chennai need a few clarification from here. If a promoter and the non-promoter having the outstanding convertible loan advance the issuer, can the issuer treat the subscription money as the after the shares? In other case, where there is a unsubscribed portion left over after the rights entitlement, can the company convert the conversion of the outstanding convertible loans to be convertible equity share? Whether open offer will be triggered off with the conversion, is it one or serial number 2 mentioned above?
See, you cannot use the word conversion of loan into a rights application money because it's different. Okay, for conversion of loans, you have to have the terms of conversion. You have to decide it and you have to pass by way of resolution, etc. The question comes that suppose, for example, if there case of a rights issue, can the shareholder say, look, my existing loan proceeds may be treated as rights issue proceeds? In case of private companies or closely held public companies, normally what we used to do is to take a letter from the person concerned that my outstanding loan amount may be treated as my subscription money, and along with an application form attach that letter. As such, there is no and then the proceeds are to be utilized as application proceeds of for that rights issue. That is the best thing. But however, Bhatia, you also may do that. See, certain times, law may not prohibit or permit everything. Only thing is you need to say that what is the spirit of the law and where to comply with that also. Yeah.
Key difference
I would
between
like
right
just,
yeah,
One
yes,
minute,
Bhatia,
Bala,
sir.
I
I
would
think.
like,
Yeah.
I would like just one line here that conversion of loan into equity. This matter has been well settled by SEBI Appellate Tribunal in June 11. SEBI has objected in one of the letter of offer that the conversion of loan provision is there. Then the company went to the SAT and SAT has upheld that there is no law prohibits it. It is very well within the provision. The
See,
June
not
6, 2011 decision of SAT is there.
and let us also understand one thing. I want to bring the demarcation between the two. One is that adjustment of the loan proceeds against the application money for the rights issue. That is not
Right.
conversion of the loan. So we have
Yeah.
to use
It's
the
not
word, the
conversion. Right.
terminology
Right.
very carefully. Don't use the word conversion. You are not converting the loan into that rights issue application money. You are adjusting
Right.
only that. Okay.
Very right. Excellent. Right.
Key difference between the right issue, private placement, and the preference share in the existing shareholders.
And all our seminars, you will feel the difference.
And what is the rate of existing shareholders can renounce the shares to the outside shareholder? That you already answered this question. It is mentioned in the slide that valuation is actually required However, pricing is also mentioned. Can you clarify?
Pardon?
It is mentioned valuation is not required. However, pricing is also mentioned. Can you clarify? That means
Right, sir. You
probably
have to have a price of any instrument. The board is to decide on price. Valuation is a mandatory process which is to be given under Section 247, whether it is applicable or not. But value for each and every instrument, there has to be a value.
the professional agency from whom which we have to obtain the valuation.
247 registered IBBI registered valuers.
Benefits of the right issue compared to the loan, if eligible from members.
It's a long debatable concept. Again, loan is a debt instrument. Equity is a costless instrument. Loan is mostly chargeable to P&L. Equity is not chargeable. Equity is permanent. Loan is temporary. Loan is a burden. Equity is a liability, but not a burden. So many factors are there, sir.
What are the various certificates required to prepare and sign by the respective parties with reference to the letter of offer?
Certificates required to be.
What are the certificates is prepared and signed in respect of the with respect of the parties with the reference of letter of offer?
With respect to
Parties. That's the word he is using. With
Sir,
by the respective parties.
respective thought. So this we will discuss after this SEBI matter is over, because then closely held companies, unlisted companies, not much certification is there. It is only that you should be through with your due diligence.
Whether the right issue of the CCD is actually permissible, equity shareholders of the company as specified securities covers CCD also.
Right.
If the company can receive the full subscription amount on the first day of the opening of the offer, can the company is actually offer on that day to be closed as mentioned in the letter of offer or on the date of the letter of offer?
I have already replied. Company can proceed with the allotment on any day prior to the closing, if it feels so in one or more tranches.
Can the share be renounced in favor of the trustees and cooperative society within the offer period?
So therefore, the definition of a member share can be renounced in favor of a person. So anybody falls in the definition of a person is eligible.
Is there any specific format to issue of the letter of the offer of the right issue?
Contents are there, no format.
Brief on valuation. Brief on
sorry, sir, but for listed companies, yes, there is a format in schedule given with the ICDR regulations. This Ravina ji will come later.
brief on the valuation procedure, how to ensure the correct valuation. So I don't think that we will have to discuss here, because as you rightly say, valuation is to be obtained from the registered valuer or with the registered people.
So
that's
our role is
altogether
not there.
This is a different matter altogether.
Right.
Okay. In a private company, renunciation only in favor of the existing members allowed, or this you have answered this.
Already handled.
Can a shareholder make an advertisement for renunciation of his right? Will it be the non-compliance in respect of the public announcement or a private placement?
So there are two aspects. A, in the closely held companies, no, it cannot be. Provocation in the market cannot be done. Second, B, in the public, in the listed companies, yes, rights and entitlement are tradable on the platform of the SEBI as per rules given by SEBI.
Price of the right issue is lower than the market price. Lower by how much? How to determine?
That we have already discussed. Expertise of the professional to decide on what instrument at what price.
Whether the unsubscribed should be shown in the balance sheet as unsubscribed.
100%, sir. Why not issued, subscribed, and paid up? They must know the difference and then treat it accordingly.
In case of the private limited company, whether they need to evaluation report of the right issue, pricing, or they can price the issue as
already
their
discussed, sir. Already discussed. I have referred to Section 56 of the Income Tax Act.
Is it pertinent to note the section?
Just 1 minute, Bala. Bala, 1 minute. In the previous question about the unsubscribed portion is there, how to reflect that in the balance sheet. See, as Mr. Bhatia has rightly said, in the balance sheet, you have to show authorized capital, then issued capital, Sorry, today my internet is not connected. But anyway, what I'm trying to say here is that the issued, subscribed, and paid up capital need not be the same. It all depends upon whether you have issued 100 rupees, whether it is subscribed 100 or not. Unless until the issued capital entirely it is subscribed and entirely it is paid up, then it would be like that.
I think voice is cracking actually.
Yeah, I will try to change my this thing around. Okay.
It is pertinent to note that Section 56(2)(6)(b) of the Income Tax Act 1961 is actually abolished with effect from 1/4/25. That is assessment year 24/25. The requirement of any valuation under the rules 11 UA2 of the Income Tax Rules 1962.
Sir, can you repeat the question, please?
It is pertinent to note that Section 56(2)(6)(b) of the Income Tax 1961 is actually abolished with the effect from 1/4/25. That means assessment year
Right.
25/26, that no requirement of the valuation under Rule 11 UA2 of the Income Tax Rule 1962.
Sir, I have already submitted, already said in Rule 11 UA to be referred in this case, read with Section 56 provisions, and the evaluation should be done accordingly.
Here he says the rule is actually abolished effective from 1/4/25. That's what he says.
But still it is there, and so many and notices have been issued by income tax authorities to many companies. I am handling 3 at present.
Okay, however, 62(1) take about the increase of the subsidiary capital, issue of the further issue, and in case of the right CCD, no increase of the subsidiary capital. Your views?
Issued capital, of course, after the board has passed a resolution, comes into existence. Then, as Mr. Sudhakar has rightly said, what portion has been subscribed, whether it is fully subscribed or partly subscribed, then we have to treat accordingly. Then, out of that, if the payment has been received after subscription, the payment has been received for full amount, it is paid up capital, fully paid, or it is less paid and accordingly treated. So, all the heads has to be dealt with post subscription of the right issue.
What could be done when the shares are less than the number of the shareholders? Right issue, private placement in case of the government company.
What happens to?
What could be done when the shares are less than the number of the shareholders? Right issue or private placement in case of the
But
government
then you
company.
have to plan your issue accordingly. What size you are planning and what ratio, what you are giving. This question is, I think, is not. I can understand. You have to plan it accordingly. What is the question of shareholders? No question. If there is 2 shareholders in a private company, yes, you can go ahead with the right issue. If there are 10, you can go ahead like that. It is the ratio to be given to each shareholder with the ratio of the existing shares they have. You have to see that size of the issue, which is the existing shareholder, then ratio is to be decided accordingly.
Somebody saying, in my view, listed companies. Listed companies, we are yet to discuss. We are talking about the company side. So this, I think, probably we'll discuss it later. Rupees 2,340 shares and shareholders are 8,364. I do not know what is this. Is probably pertaining that particular person. Is MGT 14 used to be filed before the opening of the offer, or it can be filed subsequently?
Ravina has already said 30 days from the date of board resolution.
Yeah, 30 days from the date of board resolution. Please elaborate the procedure of the right issue in the demat form. Can this public company where the most of the shares are actually holding share in the physical form? No, you need to get it converted in the demat. You cannot issue in the physical. There's a circular is very clearly there. Is there, as Bhatia said very clearly, apart from the smaller companies, all other companies, it is to be in the demat form only.
Read rule 9, read with 9A. I'll add one more thing that you discuss with your RTA that Physical shareholders who have not given their demat account, their shares will be kept in a separate suspense account. And that will not be given, right, cannot be given to them unless they give their DPID number. Once they open an account and give the DPID number, then the relevant shares will be credited to their account. Otherwise, these shares will be kept in a separate escrow account.
If a company approved the right issue for the 100 crores during the offer period, only 50 crores are actually subscribed. Can one more offer for the balance 50 crores open the next day or the next few months without fresh board approval?
Ravina ji has already said issue is kept open for maximum 30 days and issue has to be closed within 30 days. Anything is subsequent is a separate one, no relation to the previous one.
Okay, so coming back now to the right issue as per the for the listed companies, right issue is defined under Regulation 2, subsection 1, double Z. A right issue is an offer of specified securities by listed company to its existing shareholder in proportion to their existing shareholding. In case of listed company, it is dealt by Regulation 61, 62, where an issuer shall not be eligible to make a right issue of specified securities if the promoter or any of its promoter group or director of the issuer are debarred from accessing the capital market by SEBI. If any of the promoters or directors or of the issuer is a promoter of or director of any other company which is debarred, if any of its promoter or director is a fugitive economic offender. The issuer making a right issue of specified securities shall ensure that it has made an application to one or more stock exchange to seek an in-principle approval for listing of its specified securities on such stock exchange and has chosen one of them as designated stock exchange. All its existing partly paid up equity shares have either been fully paid up or have been forfeited, and it has made firm arrangements of finance through verifiable means towards 75% of the stated means of finance for the specified project proposed to be funded from issue proceeds, excluding the amount to be raised through the proposed right issue or existing identifiable internal accruals. Excuse me. SEBI LODR applies to all listed conducting a right issue, ensuring transparency, timely disclosure, and adherence to corporate governance principle. Chapter 3, Regulation 29 says intimation of the board meeting to stock exchange for approval of the right issue. Regulation 42 uh, states fixing the record date for the determining shareholder eligibility, and Regulation 50 prompt disclosure related to the right issue on the company's website and to stock exchange. Any delay in disclosure attracts penalties. So compliance checklist which we have, which is under SEBI LODR regulation, is before the issue, intimate stock exchange about the board meeting and record date, file the letter of offer with SEBI and stock exchanges, dispatch offer letters to shareholders. During the issue, we have to keep the issue open for the prescribed period, that is 7 to 30 days. Maintain active communication with shareholders and stock exchanges. After the issue, announce subscription result and disclose the allotment. Update the shareholding pattern with stock exchange. Listed company must notify the stock exchange at least 2 working days in advance about the board meeting to consider the right issue, which excludes the meeting date and the date of intimation. Remember, in Companies Act, it says at least 3 working days, but as per LODR, it is at least 2 working days. Details to disclose proposal for the right issue, key terms such as price, entitlement ratio, and record date. Fixation of record date. The company must fix a record date to determine the eligibility of shareholder for the right issue. Notify the stock exchange about the record date at least 3 clear working days in advance. It was 7 clear working days, and recently it was substituted wide SEBI LODR Third Amendment Regulation 2024 dated 12th December 2024. Maintaining the company must upload the following details on its website: letter of offer and application form, timelines and instruction for the right issue, and frequently asked question for shareholders. Disclose the outcome of the right issue to stock exchange immediately after the issue closes, including number of shares allotted, amount raised, any unsubscribed proportion, and its treatment. So here we can see the timelines: board meeting intimation at least 2 working days before, record date at least 3 clear working days in advance, dispatch of offer letter at least 3 days before the issue, subscription period minimum 7 days and maximum 30 days. In Companies Act, it was minimum 15 days, which was amendment in 2020. And over here, as per LODR, it is minimum 7 days. Post-closure disclosure immediately after the closure of the issue. Now we come to Regulations 2018. The provisions which are applicable is Regulation 72, 73, 76, and 77. And offer document says object of the issue, risk factors, and financial details. So the procedure for issuance of right shares, here we discuss as below. Check whether the right issue is within the authorized share capital of the company. If not, steps should be taken to increase the authorized share capital, which we have earlier discussed. Issue notice of board meeting to all the directors of company at least 7 days before the date of board meeting. Notify the stock exchange concerned the date of board meeting at which the right issue is proposed to be considered at least 2 days in advance of the meeting. Convene another board meeting which shall decide on the following matters, that is quantum of issue and the proportion of right issues, alteration of share capital if necessary, and offering shares to persons other than existing shareholders of shares in terms of Section 62 of the Companies Act 2013. Fixation of record date. Again, this is very important because appointment of merchant banker and underwriters has to be done. If the issue is more than 50 crores value of the issuance, approval of draft letters of offer or authorization of managing director, company secretary to finalize the letter of offer in consultation with managers to the issue, stock exchange and SEBI. The listed entity shall give notice in advance of at least 3 working days to stock exchange specifying the purpose of record date. Immediately after board meeting, notify the concerned stock exchange about the particulars of board of directors decision. File draft letter of offer with SEBI and obtain observation, if any, and incorporate the same in letter of offer. Right issue shall be kept open for 7 days, not more than 30 days. File a copy of letter of offer with the stock exchange where the share of the company are listed, and obtain in principle approval for listing of equity shares to be issued under the proposed right issue. Dispatch letter of offer and composite application form to shareholders. Check that an advertisement giving date of completion of dispatch of letter of offer has been released in at least an English national daily, one Hindi national paper, and a regional language daily where registered office of the issuer company is situated, and that the shareholder can apply on plain paper if he does not receive the application form.
But yes, sir. In fact,
Yes, please.
I like you to share your views. Wherever the right issue less than the 50 crores, the merchant banker appointment is actually not compulsory. What are your practical views, please?
Sir, you have rightly said that it's a, as Mr. Sudhakar ji in the beginning said, that SEBI during COVID came with fast track. So this is a kind of fast track issue, less than 50 crore, up to 50 crore, not less than, up to 50 crore. No merchant banker is required. Company can itself go with the all procedural requirement, including taking approval from the stock exchange, drafting of the documents, and going ahead with all the sending dispatch, allotment, etc. But practically, let me tell you that it is not possible for the company to go ahead because of the right entitlements. Now, the right entitlements, as Ravina J will come with another slide subsequently, that all right entitlements are now tradable and mandatorily tradable at the stock exchange. You have no option. So merchant banker has to help you out in obtaining a window from the stock exchange. Before that, we have to have a separate ISIN number for that. Then the trading window is kept open for trading of the rights entitlement for the period which is mentioned in the offer document. For all that, then the in principle approval, when we go to Bombay Stock Exchange or the National Stock Exchange, they want a certificate from a merchant banker that this issue is being done as per requirements and guidelines of the SEBI regulations in strict compliance of the SEBI. For all that practical reasons, how to decide the price so that tomorrow no question should come out, all the documents to be prepared as per the SEBI requirement. There is a scheduled given in the LODR regulations which describes the format. This format is not less than a small mini average prospectus. It's a big document. It's not a 2-page, 3-page document. It's a big document. Then we have to carry out a due diligence. Due diligence certificate is to be given. Then the merchant banker is to certify about all that thing. For all that reasons, this is my advice that company should have a merchant banker for coming out with the right issue of issues which are of size up to 50 crore. Right, sir?
Yes, Ravina. Thank you. Thank you very much, Bhatia, sir. Yes, Ravina, go ahead.
Yeah. So, last point of this slide, the advertisement should state the application of shareholders who apply both on plain paper and in a complete application form are liable to be rejected. Making arrangement with bankers for acceptance of share application forms, finalize the allotment in consultation with stock exchange, convene board meeting and make allotment of shares, make an application to stock exchange where the company share are listed for permission of listing of new shares. What are the things which has to be disclosed in letter of offer? So letter of offer must include the following: objective purpose for which the funds will be used, key financial data, debt equity ratio and other metrics, total size and price of the right issue, right entitlement ratio, terms of renunciation and payments, specific risk associated with the business or issue, board composition and management practices. As we heard about fast track right issue from one of our panelists, now we are going to discuss about the fast track right issue in detail. A fast track right issue allows listed company to raise funds quickly by offering shares to existing shareholders under simplified compliance norms. It is regulated by SEBI Regulation 2018, and below we will be seeing the this definition and objective. A process under SEBI regulation enabling eligible companies to conduct a right issue with reduced compliance requirement and faster timelines. The objective of Fast Track Right Issue is to streamline the fundraising process, reduce costs, and facilitate quick access to capital for listed companies. Which companies are eligible for going to Fast Track Right Issue? Under Regulation 99, a listed company must meet the following criteria to qualify for a Fast Track Right Issue. Listing duration. The equity shares of the company must have been listed on a recognized stock exchange for at least 3 years. The company must have complied with SEBI LODR regulation and other securities laws for the last 3 years. The average market capitalization of the company's public shareholding must be at least 250 crores. The company, its promoter or director must not be debarred from accessing the capital markets by SEBI. Companies eligible for FTRI enjoys the following benefit: reduced compliance requirement, no filing of the draft letter of offer with SEBI. They can directly go to the stock exchange and send to shareholder. The time required to launch and complete the issue is significantly reduced. While LOF must still comply with SEBI ICDR disclosure norms, the regulatory burden is lightly compared to a regular right issue. Savings on time, regulatory filing, and legal expenses make this process more economical. So procedure for going to for FTRI. We have to pass a board resolution approving the right issue and its terms, notify stock exchange about the board meeting and the decision to conduct a FTRI, decide and disclose the record date for determining eligible shareholders. Remember the timelines which are there in the SEBI LODR, that is the 3 day three clear days and minimum 7 days and 30 days for letter offer. It remains the same. Prepare the letter of offer and file it with stock exchange. Send the letter of offer to shareholders via physical or electronic means. Open the subscription window for 15 to 30 days. Allot shares and issue refunds within 15 days of the shares issue of closure. File the allotment detail with SEBI and the stock exchange. While SEBI provides exemption, the DLOF filing, the letter of offer must include company overview and promoter details, terms of the issue, that is price, ratio, recorded, purpose of the issue and intent to use of funds, financial statement for the last 3 years, risk factors associated with the company and the issue. So now we'll be moving to rights entitlement. Do you want to say anything, any of the panelists? So we move towards rights entitlement. A right is issued by a company to its shareholder on a predetermined date called the record date. Rights entitlements are offered to shareholder as a ratio to the number of securities held on this record date. A shareholder may refuse to subscribe to the right issue and just let the right lapse. Alternatively, the shareholder can renounce or trade the entitlement in favor of another person for a price. How do we trade in right entitlement? We can trade right entitlement on the NSE equity market trading platform. Settlement guarantee shall be provided for trades and settlement shall be compulsorily done in dematerialized mode. What if right
It is both on
entitlement?
NSE and BSE platform. It is both on NSE and BSE platform.
It is both in NSE and BSE platform. Okay, sir.
No issues.
Okay. What if the right entitlement neither subscribed or nor renounced? If it is not neither subscribed or not renounced on or before the issue closing date are lapsed post closure of the issue and the ISINs linked to these REs shall stand suspended. Right entitlement can be subscribed by non-existing shareholders. However, they need to purchase right entitlement and then subscribe to the right issue before the closure of the issue. The right entitlement will be lapsed and investor shall not get any share if the renunciation is not through stock exchange mechanism. Right entitlement would be traded on the equity market segment of NSE and, as I said, BSE as well. Separate ISIN number is required for right entitlement. How do we calculate base price? On the first day of right entitlement, the base price would be calculated as closing price of the stock minus right entitlement price. On every subsequent days, the closing price of the right entitlement trading would be the base price. Securities transaction tax is at the rate specified in the entry at serial number 4A of the STT table below section 98 of the Finance Act 2004 in respect of sale of an option in securities. Accordingly, STT shall be payable by the seller at the rate of 0.1% with effect from 1st October 2024. Earlier it was 0.0625% of the value at which such right entitlements are traded. Now we come to the non-compliance consequences. We know that right issue shares have a process, but if compliances are not done properly, then it can result to penalties for the companies and its officers. As per Companies Act, with under section 62, penalty for the company, fine up to 1,000 per day of default, penalty for officers, 1,000 rupees per day of default, non-filing of PAS 3. If the company fails to file form PAS 3 within 30 days of allotment, 10,000 rupees plus an additional 100 per day for each day of default. Penalty for officers, fine of up to 1,000 rupees per day for each day of default. Breach of notice period, offering shares without providing the minimum 15-day notice period may render the offer voidable. Improper disposal of unsubscribed shares in a manner disadvantageous to the company or its shareholders may lead to legal actions by affected shareholders, fine and penalties under Section 62, which we discussed above. Under LODR Regulation 2015, fines for failure to notify stock exchange about the board meeting or record date range from 20,000 to 55 lakh per default. Delayed disclosure, company failing to disclose material events related to the right issue may face penalties ranging from 10 lakh to 1 crore or suspension of trading. Improper handling of allotment or refunds. SEBI may impose penalties for delay in allotment or refund, including a 15% per annum interest penalty for late refunds. As per ICDR Regulation 2018, SEBI may impose monetary penalties for failing to file the draft letter of offer with SEBI or stock exchange. If a right issue fails to achieve 90% minimum subscription, the entire amount must be refunded. Failure to refund within the stipulated time results in an interest penalty of 15% per annum from the expiry of the timeline until the refund. Misleading disclosure or incorrect pricing in the offer document may result in fine, regulatory action, or even suspension of trading. Inadequate or incorrect information in the offer letter leads to penalties similar to those under Section 62. Non-dispatch of offer letter in the prescribed mode or timeline can result in fine as determined under Section 450 of the Companies Act. Not only there are penalties, but there are other consequences as well. SEBI or ROC may initiate inquiries or inspection into the company's compliance processes. Non-compliance with regulatory norm can lead to erosion of shareholders' trust and market reputation. For listed companies, stock exchange may suspend trading in the company share for violation of SEBI regulations. Shareholders may initiate legal action for failure to comply with the right issue obligation, especially for mismanagement of unsubscribed shares or incorrect pricing. We see that there is a lot of penalty and a huge penalty and lot of dangerous consequences. So the company suggested to, if they are issuing the right issue in the with the help of the advisors and your company secretary under the guidance of them. Here we will be discussing a case study just to wrap up the concept of right issue. So here it is. XYZ Private Limited, a medium-sized manufacturing company, was facing financial challenges due to the increased cost of raw material and expanding operational requirements. To strengthen its balance sheet and fund its expansion plans, the company decided to raise capital through a right issue. XYZ had been in operation for over 10 years. It has 100 equity shareholders, 50 preferential shareholders, and 10 debenture shareholders. The question is, can XYZ Private Limited issue such shares on discount? XYZ Private Limited can issue such shares on discount on market price of the shares, not on the face value of such share, as it was said by Mr. Bhatia sir. Can XYZ
XYZ Private Limited can issue shares on discount on market price, but not below the face value.
correct? Can XYZ
In
Private
case of
Limited
private company, there is no market price, it is the book value.
correct? Can XYZ Private Limited issue right shares to all the members? No, the right shares are issued only to existing equity shareholders.
Equity shareholders.
So now we come to our conclusion. To conclude, a right issue under Companies Act 2013 provides an effective mechanism for companies to raise additional capital while safeguarding the interest of existing shareholders by offering them the right to purchase new shares in proportion to their holdings. It ensures fairness through transparent procedures, offering a cost effective way to raise funds without diluting the ownership of current investors. The process is subject to regulatory compliance, which promotes transparency and protects shareholder rights. Thus, a right issue serves as a strategic tool for both capital raising and maintaining shareholder equity. Thank you. We can now
Thanks a
take.
lot, Ravina. You have brought out very nicely the concept. Very nicely you presented. I think now we'll go on to the questions, I think. Probably you can close the presentation.
Sure, sir.
What is, sir? Somebody is asking, actually asking, please, once again, will you please say the valuation rules under the Income Tax Act?
Sir, I have already requested that we should go with Section 56, read with Rule 11 UA. They have given definite parameters for valuation, and we have to go with Rule 11 UA. It could be by a chartered accountant, it could be with the background, or it could be with any other parameters from a registered merchant banker or SEBI registered merchant banker or from a SEBI, IBBI registered valuer. These valuations are acceptable by income tax authorities. So we have to read the law before we go ahead with that.
Whether the merchant banker is required for the right issue of the listed company, I think you already answered very clearly on this. Even we talked
Right, sir.
about the less than 50 crores also, we talked about it.
Right.
What would be the oldest valuation date issuance, the right issue as the private placement cases?
The right issue valuation in case of anybody this registered value, or if you are getting it done, or for the purpose of income tax act, the date should not be sorry, 6 months back. Evaluation done in 6 months is valid for, but this 6 months should be valid not only from the letter of offer date, should be valid till the end of the process.
FCNR required the valuation certificates an attachment of the allotment of the NRI.
Pardon? The
FCNR whether requires a valuation certificate as attachment for
yes,
allotment of the NRI.
yeah, it is to be filed with RBI along with Form FCGPR.
Section reference where it is mentioned that subscription money can be utilized even before filing a PS3 in the right issue. I think you discussed enough actually on this. You actually explained
Yeah.
it. What is the thing? Yeah.
Right.
In case of the private limited company, share valuation done, say rupees 7,000 rupees per share. The company issues the right share at the significantly low price, say 2,500 rupees compared to the share value of 10,000 rupees at the valuation report. Is it possible to consider, as per the Companies Act 2013 provision, rival application, rival raised voice and file the case that the company has been actually private company lost due to the low right issue, the valuation of 2,500, can it be instituted in
Already
the
requested
NCLT? Yeah.
in case of
He says, can we go to the NCLT that the company suffered the loss because of the issue rate is slow or something like that?
no, there is no role of NCLT in that. Valuation in right issue is not required. It's wholly a income tax process. Companies Act has nothing to do. So NCLT has no role, no scope on it.
In case of the demerger, the share offered, existing shareholders becomes a preferential allotment, right? And the process as per the does not become the right issue. Rights in that case, allotment money is used by the new formed company before the
Or
entire
it is,
allotment
sorry,
process.
I am interrupting. Is it demerger or it is a preferential allotment or it is a right issue? All
He
are three
talking,
different concepts.
yeah, it is seem to be some sort of the demerger
So in
question,
demerger,
I
it is
think.
the
So we won't
scheme.
take it.
In the demerger, it is the scheme which deals with the allotment of the shares exchange ratio and all that.
Can the unsubscribed waiver of the share be issued to the outsiders board the power to dispose of the share, and if not, attach provision of the PRO outsiders, the subscribers, same is not the existing shareholders. So there is no question of waiver. You actually discussed. Sudhakar explained very well. There is no waiver.
Very
It
well.
is
Section
either
62 deals with it.
hmm. Can a private company issue the shares at the right issue at the face value without obtaining the valuation report? You said
I
actually
have no.
valuation report. Valuation report we
Already told,
discussed
sir, in
yesterday.
right issue, Companies Act does not require valuation.
What is the procedure for the right issue in the demat form in case of the public company? No, this also we discussed, I think so.
1 minute,
Shareholder,
Bala.
yeah.
Bala, 1 minute, 1 minute. See, the question of valuation report, the periodical, several people are asking about this. As per the Companies Act, for rights issue, you don't require any kind of valuation certificate. Only in case of preferential allotment, it is required. Private placement, it is required. Why it is so? The only reason is in case of rights issue, you are giving every shareholder of the company, which is not so in case of other issues. So in case of other issues, if they are giving the offering the shares at too low a rate of the market value of the shares, there the existing shareholders will be losing. In case of a rights issue, no one is losing because the offer is the same uniformly to everybody. That's why in case of rights issue, valuation certificate is mandatory. In case of income tax, if there are different rules are there, you have to comply with that also. But as far as the Companies Act is concerned, for rights issue, you don't require any kind of valuation. Even if the book value of the share is 7,000 rupees, you are giving that rights price, you are decided at 2,000 rupees and uniformly giving to everybody. Absolutely, there is no issue.
Can we issue preference and equity shares under the right issue at the same time, same meeting? Is it obvious that for the preference shares, there will be an EGM? However, needed clarity to prior to the set EGM, can the same board meeting, the same valuation, we can actually issue after the equity and the preference share in the existing shareholders?
Preference cannot be issued to existing shareholders. It's only right issue. Mr. Sudhakar has just said preference is to the select group. These are two different aspects. Why they are intermingling these two things? And the board is to decide one issue, how to fund. And the funding is to be decided by the board in what manner, partially by right, partially by preference. Yes, it is possible.
It was already 3 working days gap for the record date in case of the right issue. The point is actually not amended in December 24 for right issue. Please correct me if I am wrong. No, 21st circular has actually brought the amendment. You refer the latest circular. What is the effective date of the increase in the authorized share capital? Approval of the shareholder or filing the form SI7?
I think, sir, we should have a separate session on increase in authorized capital. My London friend is asking for it. They should convene a board meeting. They should call and hold an external general meeting, then pass a resolution for increasing, then file the form SH7. Right?
Can approval for the issue of the increase of the authorized capital can be taken at the same shareholders meeting to increase the effective from the filing of the SI7?
Pardon?
Can approval for the issue of the
Say
increase of the
1 minute,
authorized
Bala, 1 minute. Bala,
yeah.
hello, 1 minute. See, the participant to understand there is a difference between corporate action and matter. Increase in the authorized capital is a corporate action. Filing the form is only a procedural part. Whether you file the form or not, it is immaterial. That consequences are there. But corporate action has been taken. One has to understand that very clear. Unless until it is clearly mentioned in the act itself, only that comes into effect after filing the form. Unlike in case of a private placement, it is there, you can utilize the funds only after filing the PAS 3. In such case, yes. Otherwise, it is not. Yeah.
If the one case the private limited company taken the money from the prospective members towards the allotment of the share, can they issue the share preference basis without issuing the right issue? The new allotment include existing as well as the new members at the same rate.
Question is not clear because the right issue is something different. I have already requested preferential is something different. Money received, if it is for right issue, no issues, it can be received in current account of the company. For preferential, there has to be separate account as envisaged in the company's section 42 requirement read with rule 12 and 13. So these are two different requirements. We have to comply with that according.
In
See,
government-owned
I
companies,
would like to add further one thing. The participants has to understand one thing very clearly. Whenever this type of questions comes, every type of issue of security has a different terms and conditions. If you are issuing right shares, if you are issuing shares on preferential basis, private allotment, private placement, every issue has its own terms and conditions. And the board has to have a clear mind in what way, which modality they are issuing the securities and how to decide the terms and conditions accordingly. At the same point of time, that and when the implementation part comes, when the letter of offer or offer your prospectus, whatever it may be, in that you have to clearly mention that which mode of issue of securities you are adopting it. In the terms and conditions, you have to mention accordingly. In case of private placement and preferential allotment, there is no question of renunciation, which is so in case of rights issue. So you have to see similarly in case of convertible, and it is going down. All those conditions are different. So don't mix up the issues.
in the government-owned companies, which execute the project as a long gestation period, the equity released installments. Such release neither come under the further right issue. How address such a situation in the light of the provision of the Companies Act?
गवर्नमेंट कंपनी गवर्नमेंट जाने पैसा दे दिया फंड आ गया लौट कर दो खत्म किसान प्रेसिडेंट का पैसा प्रेसिडेंट की मैच्योरिटी
Can a private limited company fix the right issue price at the face value itself?
व्हाई नॉट सर यू मे फिक्स एनीथिंग इन राइट इशू not an
Yeah,
issue.
so long as it is not less than the face value, that should be fine, I think.
Yeah.
Can a public company issue the share at the price of the face value? We understand that the company cannot issue shares below the face value. Yeah, that is true. It cannot be the below the face value. It can be any other price because it is decided by the board of directors to their justifications.
Face
If
value plus
unscribed
anything.
shares are not shown, if the unauthorized shares of the not, this is a non-compliance. You'll have to actually show it. Otherwise, you'll have to reopen the balance sheet as a long-term procedure. Can you throw some light on SAST exemption for equity shareholders on the right issue?
Not to pick up today.
Do we need to take a ASBA platform approval for both exchanges of the designated only?
Yes, in listed companies, yes.
The project report is required to the capex in case of the object of the right issue.
Pardon?
A project report, is it required for the capex in case of the object of the right issue?
Right. Merchant banker is there. He is to certify that the cost and, means of finance as well as the size of the issue coincide and how it correlates. They have to certify it and confirm it.
See,
For the past,
not only that, 1 minute, Bala. Without a project report, how the board will approve the rights issue? Or as a matter of fact, any issue of securities? So first of all, the management has to be very clear for what purpose the funds are going to be utilized. If it is for a
Cost of project
project, you
has to be
need a
there.
project report. If it is for working capital, you need to give the next 5-year projections. So something like that, you know.
For the
Yeah.
for the fast track, minimum 15 days is open for the issue.
Mhm.
For the fast track, is it the minimum 15 days to open the issue?
0 to 50. 1 to 50. Anything
Yes,
less
it
than
has to
50.
be. And it is mandatory.
After closing the issue, is it required to close the allotment formalities and trading formation by 15 days time?
Right.
Can the allotment of share under right issue made through the circular resolution? Earlier, the board approval of the right issue is a letter of
Already replied. Already replied, sir.
evaluation still not required the allotment of the NRI. Then how to actually file the FCGR GPR? The valuation is required. That's what you said actually here. In a
Sir, in
private,
case,
yeah,
yeah.
yes, but yes, sir.
In case of private companies, RBI is given their valuation methodology. They should see the rules regulations of the RBI. In case of listed companies, they have said that the price at which the shares are being issued to all the shareholders will be the price. So my learned friend should go to the RBI rules and master circular, master directions, which is updated up to May 23, and see the procedure rules filing over there.
In a private companies, there are actually common practice that the promoters and directors lend money to the company as and when it is required and processed new companies. When the project is actually in the execution stage, subsequently the bank while sanctioning the loan to the companies itself and their conversion into equity. This I think you discussed loan and conversion. We have
We
discussed
have
enough. I
discussed
think.
two, three
Yeah.
times, sir.
So in the year, there are 3 private placement. The company for issue the sharing the different dates, but within the same financial year. The price proposed is actually retain the same as arrived to the valuation a report obtained from the valuer, which is issuing the share for the first time. Do we need to have a separate valuation report for offer? What is the validity period of the valuation report?
I have already requested. It is valid for 6 months. There is nothing written, but it is generally acceptable if it is 6 months old.
I think that's all we have done with the questions actually.
One minute, Bala. See, in this
Yeah.
question, the person is asking in case of private companies, it is the promoters and the directors lend money. Subsequently, the bank insists for conversion of that. Can the allotment be made on rights basis? Answer is no, you cannot make. In case of rights issue, you have to offer the rights to all the shareholders, not only to the promoters and directors. So if the promoters and directors, then you have to go for a preferential allotment to the promoters and directors. You cannot adopt the rights issue route for that.
Yeah, that's all I had done
Okay.
with all the questions actually. I think we can close the session because there is no hands have been risen. All the questions have been actually answered. Bhatia sir, excellent sharing of the knowledge, giving the practical aspect of what really happened. What is the thing with your experience? As usual, like last time also, we have seen you in our platform. Very, very excellent deliberations. Which again, the number of participants, even the closing time, we say it is about 186. That shows really the interest of people who wanted to listen from an expert like you. Sudhagar, as usual, you are excellent. And in fact, your varied experience, etc., all the thing you put the inputs from different time to time. Thanks a lot, very much. Thank you very much, Ravina. Once again, I would like to appreciate a nice presentation which you brought out various issues and other things that all very nicely you done. Ashwini, your last word.
Thank you so much.
I
So we
think
close. Yeah. Yes,
we've
please.
spoken a lot about everything. Thank you, panelists. Thank you, Ravina. for a wonderful session. A lot of clarity has been gained on the subject today. Thank you. Thank you, everyone.
Thanks a lot. Thank you once again to all. Have a
Thanks to all. Thanks to all participants.
good weekend. Yet we meet next week. Thank you.
Thank you so much, sir. Thank you, panelists, for giving an insight and practical approach to this topic. It will be definitely helpful to both the corporate company secretaries as well as practicing company secretaries. Someone asked the question for the PPT. We don't share the PPT, but you'll get, you can view pres this webinar in our
Yeah,
YouTube channel.
recorded version will be disseminated.
Recorded version will be there. Thank you, Sudhakar sir, for your inputs. Thank you, Bala sir, for moderating the presentation throughout. Major missing, Miss Dipti Mehta, who is our co-founder partner. So I also thank Mehta and Mehta and the team to give me this position to discuss about the security right issue. We'll see you everyone next week with a new topic. Thank you so much, sir.
Excellent, Ravina. Thank you. We close with
Thank
this.
you.
Yeah.
Bye.